So welcome everybody to the Hunting Liability and Resources webinar brought to you by the Agriculture Law Education Initiative. I am hoping a few more folks will join us in a minute, so I will slowly start with the introduction. The Agriculture Law Education Initiative is a partnership of the Francis King Carey School of Law at the University of Maryland, Baltimore, the College of Ag and Natural Resources at the University of Maryland, College Park, and the School of Agriculture and Natural Sciences at the University of Maryland, Eastern Shore. ALEI is an initiative of the University of Maryland's Empowering the State program, and I have provided our website there, our Twitter handle, our Facebook information, and our email address. So if you haven't visited our website before, feel free to check it out. This is a little bit more information for all of you about Empower. In a nutshell, Empower brings together the two universities of the University of Maryland College Park and the University of Maryland Baltimore to create a more helpful and innovative collaboration for the folks of the state of Maryland. Here is our website, umaglaw.org. As you can see, we have a variety of different things offered on our website. We have a publications library tab. So if you go under there, you will see the easy to use and easy to understand legal resource publications that we put together. We have them on a variety of different topics, and we update those as often as we can. So if you haven't been to our website before, if you haven't been back in a while, I encourage you to check that out. We also have videos where we explain legal topics that affect Maryland farmers, and you can also sign up for our quarterly update. So you'll get an email 4 times a year letting you know what new resources we have coming out and what new events we have. You can also subscribe to the Maryland Risk Management Education blog, which is www.aglaw.umd.edu. The Maryland Risk Management Education blog is sponsored by ALEI and the Maryland Crop Insurance Education Program and AREC. We update it 3 to 4 times a week. It's a great place to find answers to common ag law questions. You can search our past posts as well, so I encourage you to sign up for that. Lastly, we have an Agriculture and Environmental Law Conference coming up. It'll be on November 17th in Annapolis from 8 to 3. That will include a light breakfast and lunch. It's going to be featuring many hot topics, including antibiotics in livestock, conservation in the 2018 Farm Bill, and hot issues in ag law. So save the date, and you can go ahead and register if you're interested at that link provided. Okay, so I am a lawyer and I can't help but give a disclaimer. Just a quick disclaimer that the information provided here today is general information and it's provided for educational purposes. It's not legal advice. For individual legal advice, please consult your individual attorney. Okay, so let's get down to it. Hunting liability. I decided to put this webinar together for a couple different reasons. But mainly to answer the questions that we get at the Agriculture Law Education Initiative regarding hunting. And we get these questions throughout the year, but especially in the fall. I figured it would be a good time to talk about now so that folks could get prepared and be ready for that fall hunting season. And liability is the main question that we get asked. People want to know what their liability exposure is when they let someone hunt on their farmland. Does it matter if they are a friend or if they are hunting for free? And what's the comparison of liability exposure when you let someone hunt for free versus if you rent your land or if you have someone pay to hunt on the farm? And here's a little spoiler alert. I'm going to get to this at the end of the presentation. However, there's some good news in this legal webinar, which we don't always get to give good news on our legal webinar, so I'm excited today. There was a recently passed Maryland law which greatly reduces landowner liability related to hunting, whether you let folks hunt for a fee or whether you're letting folks hunt for free. So I'm going to get to it, so stick with me today, and hopefully there'll be some good news for everybody at the end of the webinar. Another question we get asked is, do I really need a written hunting lease? What about insurance? And then finally, what resources are available to help me? So those are the main points I'm going to be going over today. I thought it would be helpful to start this discussion with a general discussion about premises liability in Maryland and just to sort of lay out the basic parameters. So when you own or rent land in Maryland, the extent of the duty of care you owe the visitors on the land depends on the classification of that person. So what does that mean? Well, there's 3 classifications of visitors according to Maryland law. The first one is a trespasser. We're all probably pretty familiar with that, with what a trespasser is. Then there is a licensee. Licensee is actually broken down into 2 different types of licensee, a bare licensee and a licensee by invitation. And then finally an invitee. So let's go through these. Trespassers. We get lots of questions at ALEI about trespassers. Unfortunately, it's just a part of your reality if you own some acreage. So a trespasser is a person who enters your farmland without your consent and remains there without your consent, and it can include children. What's your duty of care to a trespasser? Well, the good news is that it's not a whole heck of a lot. Your duty of care to a trespasser is to refrain from causing willful or wanton injury to the intruder. Let's go back for a second. What does that mean, willful or wanton injury to the intruder? That means you would have to do something to purposefully hurt the trespasser, such as setting up, if you knew folks were riding ATVs across your property and your farm had been getting torn up because of the ATV use, and instead of posting no trespassing signs, or instead of calling the Department of Natural Resources or your local police department, you put up a thin wire across a trail, hoping that the person would ride the ATV and then get struck by the wire and fall and get injured off of the ATV. That would be an example of willfully or wantonly injuring someone. We rarely get those occurrences, so the good news is that if someone is clearly trespassing, in most instances, you're not going to have a duty of care to take care of that person on your property. However, that being said, you do need to be careful to post your property with no trespassing signs if you've had this issue before, so it's very clear to folks that they would be trespassing and that it is your property, because sometimes it can happen unintentionally. Okay, a licensee. A licensee is a person who's privileged by proper consent to be on the property for his own purpose or convenience. A bare licensee is one type of licensee, and that's someone who has permission to be on the property but is really there for his or her own purpose. Your duty of care to a bare licensee is to, again, to refrain from willfully or wantonly injuring him. And that's a theme that'll keep coming up today. There's no real excuse to willfully or wantonly injure anyone who's on your property at any time. But you also have the additional duty to refrain from creating new and undisclosed sources of danger without warning the person. So the next type of licensee is a licensee by invitation. This is a social guest that you invite onto your property, such as a party guest. The legal duty of care you owe to a licensee by invitation is to take the same care of the guest as you would take of yourself or members of your family. So you have to exercise reasonable care to make the property safe, and you have to warn the person of known dangers that could not reasonably be discovered by the guest. For example, let's say it's the fall, you know that there's some uneven terrain, but the uneven terrain is covered by leaf cover, and you know that the party guest is about to walk in that area and may not know that they're about to be walking in an uneven area because of the heavy leaf cover. Your duty is to warn the guests about the holes on the property. So it's still a pretty reasonable duty. Lastly, an invitee. An invitee is the person who has you need to give the highest level of care to. There's someone that's on your property for your economic benefit, such as a person who's paying to hunt, or if you have an agritourism operation, someone who's paying to be on the property. The duty of care to an invitee is to protect them from unreasonable risks and to keep the property reasonably safe. So if someone's paying to be on your property, basically for any reason, you have a higher level of care. You have to take that extra step to make the property reasonably safe. So you have to inspect the property for dangerous conditions, warn the folks of dangerous conditions, and remedy the dangerous conditions once you know about them. And this type of injured party is likely to have the strongest case in court. Okay, so that's the basic parameters of premises liability in Maryland. If you'd like to get a little bit more detail on that, or if you'd prefer to watch a video rather than listening to me, there's a link here that I've provided. That's an ALEI premises liability video, and we also have another video explaining the defenses to premises liability. And there's our general link for additional videos. Okay, so let's get a little bit more in depth into specifically recreational uses. So Maryland has a recreational use statute. Many states in the country do. It just depends state by state whether states have adopted these. And what it means is that if you let others use your land for a recreational use, and hunting is included in those recreational uses, it's pretty broadly defined, for no fee, meaning you don't charge them anything, then your duty of care is reduced from that of the duty of care you would owe the person is reduced from a licensee to a trespasser. So as I just explained, you would have a very low duty of care for that person. And like I said, the land has to be made available free of charge, and you can't be selling anything on the property. However, not included in the definition of fee is a share of game, fish, or other products from the recreational use. So if you let folks fish on your property for free, they can share the fish with you or the game with you, and that's not considered a fee arrangement. Maryland's recreational use statute was passed to encourage folks to allow others to use land recreationally. You know, it was understood that people were hesitating to let the public at large and other folks use property for recreational purposes because of the fear of liability. So to take away that fear of liability, the recreational use statute was passed, and there is one case in Maryland interpreting the statute and upholding the statute, so we have a little bit of case law on this, and I think it's a good law, and it's something that landowners should keep in mind. I try to educate folks about it and let people know about it. You know, I've had to explain to folks before when they've said that they had school groups, Boy Scout groups, that sort of church groups, that sort of thing coming out, and they thought they were actually in better legal standing to charge a small fee to the 50 cents or $1 or $5 a person. I would, if you're at all concerned about liability on your property, which you should be if you have people coming on to recreate on your property, in most cases you're better off to charge them nothing and then to be able to take advantage of this lower duty of care. Okay, and then finally, benefits arising to the land from the recreational use are not considered charges. So let's say you let folks hunt on your property for free because to you the game management benefits that you got are worth it, and that is a benefit arising to the land that would not be considered a charge. And contributions in kind, services, that sort of thing, also not considered a fee. Okay, so again, the recreational use statute does provide you a benefit by changing your duty from that of from someone who would have a duty for a licensee to a trespasser. However, the recreational use statute does not prevent you from still having to avoid gross negligence, and gross negligence would include willfully, maliciously failing to guard or warn against a dangerous condition, use, structure, or activity. So yes, the recreational use statute is very beneficial and can help folks. However, you still do need to inspect your property, and you still do need to warn folks about dangerous conditions. It's not a total shield. You can always face liability if you are found to be grossly negligent. And by grossly negligent, you'd have to be doing one of those things explained right there in the slide. Okay, so let's focus more specifically on Maryland's hunting laws. So Maryland does have some laws on the books about hunting. So according to Maryland law, a person may not hunt on another's property without written permission of the landowner's agent, or lessee. And that's in the Natural Resources article. So you do need written permission to be on another's property when you hunt. The Maryland Department of Natural Resources has created an easy-to-use pre-printed permission card for this purpose, to help landowners and to help hunters with this requirement. So there's the link provided in the slide. The permission card allows the landowner to give permission to the hunter to be on the property, and it's subject to agreeing to observe every safety precaution and practice, to take every precaution against fire, and assume all responsibility and liability for their own safety while hunting. More Maryland hunting laws. There is a law dealing with liability of the hunter. So any person hunting on private property is liable for any damage the person causes to the private property while hunting. So that's helpful for landowners. That's in the Natural Resources article. Additionally, there is a statutory reference for liability of the landowner, so that landowner may not be held liable for accidental injury or damage to the person, whether or not the landowner or the landowner's agent gave permission to hunt on private property. So before, well, I mean, actually today, this is the extent of Maryland's laws pertaining to hunting. These are the protections that are there for the hunter and for the landowner. However, in the last legislative session, a new law was passed. It is a legislative change, and it expands a liability exemption which previously applied to off-highway vehicles and cross-country skiing. As of October 1st, it will be effective. It was passed last session, but it won't be effective until October 1st. So under the newly amended law, a person who uses the property of another for hunting impliedly consents to adhere to every law, observe every safety precaution and practice, to take every precaution against fire, and to assume all responsibility and liability for their own safety while hunting. So you can see this, this mirrors what's available on that DNR pre-printed card. So a lot of folks are excited about this. It is very beneficial for landowners who allow hunting on their property. It's not effective until October 1st. I think everyone should keep that in mind. However, it's great. It's really a game changer. It's intended to greatly reduce liability exposure and associated insurance costs for all landowners who let others use their land for hunting. So it was specifically passed to try to encourage more use of land for hunting and to try to protect landowners from that liability exposure. It's basically analogous to getting a waiver from a hunter in which he has assumed all liability. So we've all gone to places. I know typically I end up signing them when I'm with my kids someplace where they want me to assume all liability before my kid goes in the bouncy house or whatever it may be. So getting individual waivers from folks, although I think in a lot of situations that is a great idea. However, in the hunting situation, it's not always very practical because sometimes, you know, you might run out your land for hunting and then people are out there on the weekend. You don't know exactly when they're coming. It doesn't lend itself very well to getting an individual waiver from folks. But this new law is basically acting in the stead of getting an individual waiver from a hunter because they're assuming all liability. Again, a landowner still has a duty to refrain from willfully or maliciously failing to guard or warn against dangerous conditions, uses, structures. So a landowner still has a duty to not be grossly negligent. And the only other thing I would really say about this is that it is a new law. It's going to be effective this fall, but it hasn't been interpreted by the courts. So anytime a law hasn't been interpreted by a court in Maryland, I would warn folks to use a bit of caution in relying too heavily on it. Seems like, when we haven't had a judicial interpretation yet, it's reasonable to be a bit cautious. Okay, so ways to limit liability. I like to think about limiting liability exposure like you're layering on clothing to go out in the winter and you're not really quite sure if you're going to need all those layers, but it's a better idea to just put them all on. So when you're trying to reduce your liability exposure, don't just count on one thing. Don't just think that that new law is going to be the silver bullet, or that the fact that you have your property set up as a business organization such as an LLC, or don't just count on your insurance. Layer that liability reduction so that you'll have a better chance of having as little exposure as possible. The ways to do that: landowners should regularly inspect their property for dangerous conditions. This is just a good idea. If you're having folks on your property, whether they're paying to be there or not, set some regular times where you're going to walk the property and inspect the property for dangerous conditions. You know, dangling, branches that look like they're getting ready to fall on folks, holes in the ground, that sort of thing. It's a good idea to do it, and it's a good idea to, if you observe a dangerous condition, take that extra step, eliminate all those dangerous conditions. How can you eliminate dangerous conditions? A good way to do that is to install no trespassing signs. If there's certain areas of your property you do not want people to go into, let's say you are okay with folks hunting on the back 40, so to speak, but you don't want them near your house where they could potentially, shoot a dog or injure someone in your family who's walking around. So make sure that your property is properly labeled. Install no trespassing signs, or you can use the blue blazes, as long as you're comporting with DNR regulations on that, on trees surrounding your property, especially if your property has, roads surrounding it. Rope off or fence areas you don't want people to enter, and install warning signs if they're needed. If you have a chemical shed on your property, put a warning sign on it. Tell people don't enter it. Just always a good idea to take those extra steps. It's also a very good idea to discuss the recreational uses of your property with your insurer. Make sure that you have adequate insurance coverage. Don't assume your farm general liability policy is going to cover all the recreational uses of your land. It's a bad thing to do to assume you're going to be covered. It's a much better policy to have that conversation with your insurance provider and just to make sure that you are covered and that you don't need to buy some additional rider type policy to cover you. A hunting lease, you may be thinking, you just told me we have this great new law protecting landowners, that my liability is reduced. Why would I need a hunting lease? There's a lot of reasons to get a hunting lease. I still think it's a good idea if you're charging someone to be on your property to get a hunting lease. And so I will go through some of these. It's not an exhaustive list, but anytime you're entering into a contract, which is what a hunting lease is, if you're accepting payment for the use of your land, it's a good idea to get it in writing. It doesn't have to be complicated. It's a good idea to define the terms of the transaction. For example, what area is allowed for hunting? Be specific about which part of your farm you're allowing the hunting on and which part of your farm you're not allowing the hunting on. If you don't have it in writing, there's really no way to prove that, and there's no way to keep someone off of areas you don't want them to enter unless you have it specifically in writing. Maybe you want to specifically define who you want to hunt. I mean, I have friends who complain about this a lot. I let so-and-so hunt on my property, we had a deal, and then they brought their brother, and then they brought their friend, and then they brought their cousin, and it ends up to be a much larger group than the landowner was originally comfortable with. So define who is permitted to hunt on the property. Define the term of the hunting lease. Is it a season or is it a year? Maybe you want to reserve a personal right for you to hunt or for someone in your family to hunt. If that's the situation, you should put that in the lease. I know that a lot of farmers are concerned about game management on the property, trying to reduce that crop damage wherever possible. You can specifically put in a lease that you want hunters to take certain types of game for management purposes. That's a great thing to put in a hunting lease on farm property. For example, requiring hunters to take antlerless deer to help reduce damage. Perhaps you want a right to terminate the lease upon sale of the land or the death of either party or for another reason. Leases are, if you have a lease, it can survive a sale of land. It can survive the death of either party. And in many instances, that's not actually what folks intended. That's not what they want to happen. If the land is sold, they probably want the lease to end, or if one of them dies, they probably want the lease to end. So to be crystal clear about that and to not have an issue, your best course of action is to put that in writing in your lease. You wouldn't want it to upset a potential sale of property. What about if the hunter violates hunting or fishing laws? What if you observe that, the person is not hunting to the standards that you feel comfortable with on your property and that they're in violation of the law? In most instances, you'd want to terminate that lease. If you don't have that in a written lease, you're not going to be able to do that. And finally, reducing liability exposure. Even though we have some new statutory protections, it's still a good idea to include an indemnity provision in your hunting lease and to require the hunter to defend and hold the landowner harmless from legal claims. It's another layer of liability reducing action that can really help you. Okay, so resources. Good news is there's lots of resources to help folks. Jonathan Kays is an extension specialist with the University of Maryland Extension. Here's his email. He's currently on sabbatical, but he's going to be back this fall. He had done a webinar on this topic a couple of years ago, and it's great. So I provided the link to the webinar there if you want to look back on his webinar. It was, because it was done in 2013, it was before this new law. And he's also drafted an extension bulletin on this topic that goes into much more detail than I've been able to go into today, and so there's a link to that extension bulletin. So if you want more information, and he's also got some sample hunting leases as well in that extension bulletin. So he's a great resource, and the webinar and his bulletin are also wonderful resources for you to check out. The Maryland Department of Natural Resources, clearly they can provide a lot of help. They have a guide to hunting and trapping in Maryland, so there's a link to that. And then finally, if you need someone to draft a hunting lease for you, or if you need some individual legal advice, I would suggest you turn to the agriculture law section of the bar. And there's a link to the legal services directory, so you can find a lawyer who is well-versed in agriculture issues in your area. So that's the end of today's webinar. If you logged on late, don't worry. I've been recording today's webinar, and I'm going to post it on the ALEI website. So that is umaaglaw.org. So you can check that out next week. I will have it posted up on our website. I want to give a special thanks to Paul Petito. He's the Director of Wildlife and Heritage Service at the Maryland Department of Natural Resources. He helped me with putting this together today, and I want to ask if anyone has any questions. If you do, feel free to type them in the chat box. If you think of a question after today's webinar and you would want to get in touch with me, there's my email and there's my phone number. You can feel free to reach me at any time. Happy to do research or give you some more insight into any of these areas.